Welcome to the Judicial Committee of the Privy Council, where we are hearing an appeal from the Court of Appeal of the Cayman Islands. This is the second day of the appeal. The essential is whether the Bill of Rights, forming part of the Constitution of the Cayman Islands, provides same-sex couples with a right to marry. We're currently hearing submissions on behalf of the Governor of the Cayman Islands, presented by Ms. Rose, Queen's Counsel. I'll turn now to her and invite her to continue her submission.
Thank you very much. When we broke yesterday, we were about to turn to the case of Matadine and Pointu, and I'd like to invite you to turn that up now. It's at page 3300. And this is a case that's usually cited for Lord Hoffman's general comments on the principles to be applied to the interpretation of a constitution. However, it's also interesting because of his discussion about the different ways in which countries have chosen to address the principle of equality. As Lord Hoffman explains in this judgment, some jurisdictions, like the United States, have adopted an overarching constitutional guarantee of equality before the law. Others have provided for more limited constitutional rights to equality, which prohibit discrimination on specified grounds or in specified circumstances. Some, like the United Kingdom at the date that he was writing, had no entrenched constitutional rights at all, but depended on a system of parliament regulated by judicial review. The point that he makes is that whilst accepting that the principle of equality is indeed a universal principle, and he describes it as an axiom of rational behavior, the question of the extent to which that principle should be justiciable is a question on which democracies may legitimately make different choices. And different democracies have chosen to adopt different balances between the role that the courts play and the role of Parliament in this sphere. Now, I just want to show the court the key passages relating to that point, as well as to the interpretation of constitutions more generally. The context in which this arose was the Constitution of Mauritius. Well, what had happened was that there used to be a system whereby children were ranked in order to get coveted places in secondary schools, and the higher you were up the ranking, the better it was. And it was originally, the ranking was originally based on their performance in 4 particular subjects. And then at very short notice, the government introduced a 5th, which they could choose as one of their 4 if they wanted to, and that was study of an Oriental language. And the complaint was that the introduction of the Oriental languages option discriminated against children who had not previously studied Oriental languages, and that this was unconstitutional, contrary to a guarantee of equality in the Mauritius Constitution. And so if we then go to page 3308, you can see the issue, and in particular, you can see set out there the relevant provision, section 3 of the Mauritius Constitution, that was said to have been violated. Then over the page at 3309, Lord Hoffman records the point that the Supreme Court in Mauritius found that this legislation was unconstitutional. And he says, just below the letter C, the basis of the court's decision was its interpretation of section 3 as containing a general justiciable principle of equality, a constitutional requirement enforceable by the courts that the law or administrative action under the law should treat everyone equally unless there was a sufficient objective justification for not doing so. A similar principle has been found by the courts to exist in the constitutions of certain other countries, notably the United States, where it's been derived from the equal treatment clause of the 14th Amendment. And the court will bear in mind that, of course, it's that provision, the 14th Amendment equal treatment provision, which is in fact the basis for the decision of the Supreme Court in Obergefell, on which Mr. Fitzgerald relies in these proceedings. So then at page 3310, at the top of the page, just by the letter B, Lord Hoffmann says the reasoning of the Supreme Court, and in particular its formulation of the general justiciable principle of equality, raises a question of fundamental importance about the relationship between the courts and the legislature of Mauritius. And he then goes on, this is the famous passage with which I know this court is very familiar, where he describes the process of constitutional interpretation. And he acknowledges that construing a constitution is different from construing a commercial contract because the context is different. The background of the constitution is an attempt, as he says, at a particular moment in history to lay down an enduring scheme of government in accordance with certain moral and political values. An interpretation must take these purposes into account. He then goes on to say that it's a mistake to suppose these considerations release judges from the task of interpreting the statutory language and enable them to give free rein to whatever they consider should have been the moral and political views of the framers of the Constitution. What the interpretation of commercial documents and constitutions have in common is that in each case the court is concerned with the meaning of the language. And then he cites Kentridge, the South African Constitutional Court. If the language used by the lawgiver is ignored in favour of a general resort to values, the result is not interpretation but divination. And as the court knows, we rely on that principle, which we say again is echoed by Lord Bingham in Rays, where in fact Lord Bingham cites this passage. But he then turns specifically to the construction of Section 3. And he makes the point that the Supreme Court do not appear to have paid much attention to its language. And instead what they said was that the main thrust of the judgment was an assertion that such a principle was essential to a democracy and therefore to be implied on the basis of Section 1, which is the section that says that Mauritius is a democracy. And essentially this is a living tree approach, that what's said is the principle of equality is now has now evolved as a universal principle and therefore essential to a democracy and therefore ought to be implied into Section 3. Lord Hoffmann then goes on at paragraph 9 on page 3311 to make some comments which again are extremely well known about the principle of equality. And he accepts that it is an axiom of rational behaviour. But then he goes on in a somewhat less often cited passage to say, but the very banality of the principle must suggest a doubt as to whether merely to state it can provide an answer to the kind of problem which arises in this case. Of course, persons should be uniformly treated unless there's some valid reason to treat them differently. But what counts as a valid reason for treating them differently? And perhaps more important, who is to decide whether the reason is valid or not? Must it always be the courts? The reasons for not treating people uniformly often involve, as they do in this case, questions of social policy on which views may differ. These are questions which the elected representatives of the people have some claim to decide for themselves. The fact that equality of treatment is a general principle of rational behaviour does not entail that it should necessarily be a justiciable principle, that it should always be the judges who have the last word on whether the principle has been observed. In this, as in other areas of constitutional law, sonorous judicial statements of uncontroversial principle often conceal the real problem, which is to mark out the boundary between the powers of the judiciary, the legislature, and the executive in deciding how that principle is to be applied. And we respectfully adopt that comment as being essentially the question that underlies this case as well. That the argument that's made by Mr. Fitzgerald is essentially the argument that was being made by the claimants in Matadine. it said equality of treatment, and in particular equality of treatment for same-sex couples, is now recognized as a universal value, and therefore this constitution must be interpreted so as to give protection to that value to the extent of including a right to same-sex marriage. But in our submission, the therefore is a non sequitur. And the reason it's a non sequitur is for the reason given by Lord Hoffmann here, that it is perfectly legitimate for a democracy to conclude that there are some forms of equality that will be entrenched within the Constitution itself, but other questions, particularly where social values are continuing to evolve and change, which will not be included as an entrenched justiciable right, but which will be left for Parliament to decide. And what Lord Hoffmann is explaining here is that that is a legitimate choice. You do not have to have a 14th Amendment approach to equality. And you can see he goes on at 3312 to develop this argument further. And in particular, just at the letter D. And he makes the point that the 14th Amendment model there is not the only possible one. And indeed, what your lordships and your ladyships have seen from the case law that's been cited in these proceedings is different potential approaches. In the constitutions of South Africa and Canada and the United States, there is no definition of marriage, and there is an overarching freestanding principle of equality. And it's the combination of those two factors that has led the courts in those jurisdictions to conclude that the Constitution includes a right to same-sex marriage. But the European Convention on Human Rights and the ICCPR have taken a different approach, which is to define marriage and to define it in terms that indicates that it is a relationship between parties of the opposite sex. And the courts interpreting those provisions have concluded that that is the lex specialis on marriage, and that at least while there is not an overwhelming consensus from the states parties to those conventions in favor of same-sex marriage, that remains the lex specialis, and it remains a matter for individual states to decide whether they will include same-sex marriage in their own jurisdictions. And that is the constitutional model which has been adopted by the Cayman Islands. Not the 14th Amendment or the South Africa or the Canada model. And as Lord Hoffmann makes clear here, that is not second best. It's not in some way disreputable. It is simply a decision to place the line between what is the realm of the courts, what's justiciable, and what is the realm of Parliament, a matter for a democratic decision making, in a slightly different place. And you see, he develops the point further, just below the letter F on page 3312, going down to the bottom of the page. And then at 3313, D to H, the point is developed further, and he concludes at G, it's open to a democratic constitution to entrench a general principle of equality, as in the United States and India, to entrench protection against discrimination on specific grounds, as in New Zealand, or to entrench nothing, as in the United Kingdom. And then he says, which has been adopted is a matter of construction, the individual constitution. So that's what I wanted to say about Matazine. I'm still on the topic of the right approach to the interpretation of a constitution. And I now want to come to the principle that has been called the lex specialis, but in my submission is perhaps more comprehensively understood as the principle that a constitution must be read as a coherent whole. Because in my submission, that is the principle that underlines both the idea of lex specialis as it's been used by the European Court of Human Rights and by the UN Human Rights Committee under the ICCPR in relation to the marriage right. And it's also the notion that underlies the Latin maxim generalia specialibus non derogant. And in my submission, rather than focusing on the hypnotic effect of Latin tags, it's better to focus on the rationale for them. What is the principle that is being encapsulated by these maxims? These canons of construction, indeed canons of construction generally, are about the application of logic and common sense to a document in order to deduce its intended meaning from its language and its context. And the canon of construction we're concerned with here is the idea that you need to read the document as a whole with the intention that it hangs together as a whole, because the drafters must be assumed to have intended to create a coherent code that is not internally inconsistent. And that is what these principles are seeking to assist with. And we say that that has two particular implications in relation to the Bill of Rights that we're considering. First, a construction that involves a provision of the Bill of Rights being rendered redundant or misleading or incomplete or inaccurate recitation of rights and obligations is unlikely to be correct. Because it is unlikely that the drafters of a constitution would have intended that outcome. And the second proposition is this, that a provision that deals specifically with a matter in question should be taken to be the primary provision dealing with that matter. General provisions should not undermine the intended effect of provisions that have been specifically drafted to deal with the particular case. And that last proposition that I have outlined is in fact a relatively accurate translation of the maxim generalia specialibus non derogant. And there are two cases that I want to take the court to in relation to these principles. The first is Mirabux. That's in page 1335. So Mirabux concerns the construction of the Constitution of Belize. And the issue in this case was that there was a specific provision in the Belize Constitution which dealt with the procedure for disciplining or removing members of the judiciary. And there was then a general principle that hearings should be heard in public. And the specific provision dealing with the removal of judges gave what appeared to be a very wide power to the tribunal in question to dictate its own procedure. And the question was whether by implication that power was to be taken as limited so that the tribunal did not have the power to sit in private. That was the question. Now, Mr. Fitzgerald sought to distinguish Mirabux by saying, oh, well, the facts are very different from the facts of this case. because there were two discrete codes in issue there, one about judicial hearings generally, one about the process for the removal of judges. Now, of course, the facts are different, just as the facts in Reyes and in Matadine and Puanto are very different. But we're not looking at these cases for the facts, we're looking at them for the principles that can be deduced from them as to the right way to interpret a constitution. So the Privy Council, faced with that question, concluded that the answer was that the specific provision which dealt with the process for the removal of judges was not to be read as by implication subject to the more general provision for hearings to be in public. The reason being that the specific provision that dealt with the matter in hand was to be given precedence in order for the Constitution to be read as a coherent whole. And you can see that at paragraphs 33 to 34, page 1352. They pose the question, and then they say their lordships consider that the answer to it is to be found in the fact that the subsection cannot be divorced from its context. Section 2 of the Constitution provides that the Constitution is the supreme law of Belize. It's the Constitution as a whole that is the supreme law, and the Constitution must be read as a whole. No part of it has any preeminence over the other unless the Constitution itself so provides. Section 6.8 is designed to reinforce the fundamental guarantee at 6.1 that all persons are equal before the law and entitled without discrimination to the equal protection of the law, but it must be assumed that the framers of the Constitution had that fundamental guarantee in mind when they were addressing themselves to the composition and powers of the BAC and the functions that it was to perform. It must also be assumed that they had it in mind when they were devising the procedure that should be followed for the removal from office of a justice of the Supreme Court. They had the opportunity, if they were so minded, to make it clear that the guarantee at section 6.8 applied to these proceedings. The provisions that deal with these matters contain no hint that they must be read subject to the provisions of section 6.8. On the contrary, section 98 provides that if the Governor-General refers the question of removing a justice to the BAC, it shall sit as a tribunal in the manner provided at section 54, not be subject to the control of any other person of authority, and shall regulate its own procedure. These provisions are stated in the clearest terms. They contain no ambiguity. They're unsurprising when read in the light of the provisions elsewhere. And then they say that the primary function of the BAC is to control the exercise of its powers, and essentially that is the specific provision that applies. Now, my submission, the approach that we are inviting this court to adopt to section 14 of the Constitution and its place in the context of sections 9 and 16 and the scope of sections 9 and 16 when dealing with the question of marriage raises precisely the same question. It's about reading the Constitution as a whole and assuming what the intentions of the drafters are. But before we leave this, of course, whenever construing a piece of legislation, the task of the court is always focused on what is assumed from the language and the context to have been the intention of the drafters. And the suggestion by Mr. Fitzgerald that that's not the test is in my submission wrong. So that is Mirabux. And we see a similar approach in a slightly different context in the case of effort shipping, which is at page 2752. So effort shipping was a case about a bill of lading that incorporated the terms of an international convention, the Hague Rules. And there was a dispute between the shipper and the carrier arising out of the carriage of goods on the ship, which was said to have been dangerous and to have damaged other goods on the ship. And the question was whether the shipper was liable as a matter of strict liability for the carriage of dangerous goods, or whether they were only liable if they were shown to have been negligent. And there were two provisions of the Hague Rules which were argued to be in conflict. And if you go to page 2759, opposite the letter B, you can see there Article 4, Rule 6, which is a specific provision dealing with the shipping of dangerous goods. And that appears to impose strict liability on the shipper. But then, if you go to page 2760, opposite the letter F, there's a general provision for the liability of the shipper, saying that the shipper shall not be responsible for loss or damage sustained by the carrier or the ship arising or resulting from any cause without the act, fault, or neglect of the shipper, his agents, or his servants. So the shipper was arguing that that should be the dominant provision, and therefore, unless they could be shown to be negligent or been at fault, they shouldn't be liable. And the House of Lords disagreed. The conclusion of the House of Lords was that the specific provision dealing with dangerous goods was to take precedence on an application of the maxim generalia specialibus non derogant. And in particular, you can see this from the speech of Lord Cook. If you go to page 2774, and in my submission, what you can see here is that in this context, the rationale is exactly the same. It's about reading the document as a whole and coherently. So what you see just below the letter B, before your Lordship's committee, counsel for the respondent ship owners introduced the expression freestanding to describe the rights and obligations under Article 4, Rule 6. It does not seem to me that this is a happy description. Like every other legal document, the rules have to be read as a whole, and Article 4, Rule 6 is an integral part of them. In truth, there's no difficulty in reconciling with it, Article 4, Rule 3, if in the latter the word act is treated as including an act of shipping dangerous goods without consent. So he gets out of it by construction in that way. But then he goes on at D to say this: if, however, there were any prima facie conflict between the general provisions of Article 4, Rule 3 and the special provisions of Article 4, Rule 6, it would seem to be almost a classic case for applying the maxim generalia specialibus non derogant. This would not be to treat Article 4, Rule 6 as freestanding, quite the reverse. It would be to conclude that on a fair reading of the rules as a whole, Article 4, Rule 6 must take priority over Article 4, Rule 3. Further reasons supporting that conclusion, as representing the likely intention of the drafters, have been given by my noble and learned friends. It would be superfluous to repeat them. I would add only that the generalia specialibus maxim, as its traditional expression in Latin indeed suggests, is not a technical rule peculiar to English statutory interpretation. Rather, it represents simple common sense and ordinary usage. It falls within the category explained in Benham. A linguistic canon of construction reflects the nature or use of language generally. It does not depend on the legislative character of the enactment in question, nor indeed on its quality as a legal pronouncement. It applies in much the same way to all forms of language. Linguistic canons of construction are not confined to statutes or even the field of law. They're based on the rules of logic, grammar, syntax, and punctuation, and the use of language as a medium of communication generally. Now, I show the court that. Yes, my lady.
It may be that you're about to cover this, but let me just air the point, why, if I may, while you're looking at a commercial contract and we're talking about linguistic canons of construction, what we are concerned with is the interpretation of a constitutional document and a Bill of Rights. And we know from Lord Sankey in the Living Tree Doctrine and lots of other places, Matt, at the point to you, that we must apply a different approach to interpretation. And therefore, it seems odd to me, anomalous, that you should be inviting us to apply plain and ordinary rules of statutory construction to the issue before us of working out the meaning of section 14. And what I would like to put to you is this, that lex specialis in the context of constitutional interpretation has a different function and a different meaning. If I take as an example, by way of background, a case in which I sat in Strasbourg called Z in the United Kingdom, there was a question there of whether there was a violation of Article 8 by reason of the local authority failing to have regard to the interests of children within its care, within its purview. Well, and what happened when the level of severity of treatment to the children attained Article 3 standards, and that the court simply says that Article 8 is subsumed within Article 3. So what I'm going to put to you is that we're not really concerned with linguistic canons of construction. We are concerned with a constitutional doctrine, a doctrine of constitutional interpretation for the purpose of working out conflicts between different rules. Because what you say is section 14 is plain on its face. It is limited to one institution of marriage, and that therefore you can't come up using other rights in the Bill of Rights to challenge it. That's my point. It has a more substantive and dynamic operation in this context.
My lady, I respectfully would not dissent from anything your ladyship says. I think the only difference between us is perhaps the use of the term linguistic canon of construction. But the point that I'm seeking to make is that you're always engaged in a process of interpretation, as we know. Of course, the context will be very different depending on whether you're looking at a commercial document or a constitution, but the essential question is the same. And the underlying rationale, whether you call it lex specialis or whether you call it the generalia specialibus maxim, the underlying rationale, as you can see from the two passages I've just shown you, is the same, because you're asking in both questions, looking at this document or this constitution as a whole, is this a coherent or appropriate construction? And
yes, my point was it might be more than that. I can see that.
Well, it might, yes, indeed, my lady, it might indeed. And your ladyship's right that, of course, if you're looking at the democratic choice that has been made by a particular parliamentary democracy to define a particular right in a particular way, that is a choice to which respect must be given, whether you call it a substantive question or an interpretation question. But ultimately, my submission is going to be that where you have a constitution that very clearly intends to give a constitutional right to marriage that is limited by particular conditions, it is not appropriate then to imply a much wider right to marry without those limiting conditions from other general provisions in that constitution. Mm-hmm. And however you characterize that exercise, in my submission, you come out at the same place when you're looking at the document and seeking to understand it as a coherent constitutional whole.
Thank you.
Now, we do submit that whether you call it lex specialis or the generalibus maxim, however you want to characterize it, what it means is that the right place to start when you're seeking to interpret the Constitution is with section 14, the provision that deals specifically with marriage. And we submit that one of the errors in the approach taken by the appellants in this case is that both in their written case and orally, what they have sought to do is, first of all, to produce an interpretation of the Bill of Rights as if it had existed without section 14. And then to say, aha, section 14 is an ouster clause that's limiting the right to same-sex marriage that would otherwise exist under Section 9 read with Section 16 or Section 9 alone. Now, we say that is completely the wrong way round, that the right question is to start with Section 14 and the carefully delineated scope of the right to marry, and then say, is it plausible that having enacted that right, the legislature would at one and the same time have made an enactment that rendered it both misleading and OTOs in its scope? And we say that's not plausible. And the sleight of hand that my learned friend does by approaching it that way around is to in some way establish some pre-existing right to same-sex marriage, which he then characterizes as having been ousted by Section 14. But there never was a right to same-sex marriage in the Cayman Islands, and there never has been. There was no such right at common law, and there was no such right under the marriage law when that was amended in 2008, before the Constitution came into effect. So there is no external source for such a right. The next point I want to turn to on constitutional construction is the living tree principle. Now, the appellants lay significant weight on the living tree principle, and of course we agree that it is an important principle that is applicable to the interpretation of a constitution. But whether it makes any difference to the result will of course depend on the particular case. In this case, the board is considering a very recently drafted Bill of Rights, where there is no evidence that social attitudes in the Cayman Islands have changed since it was originally adopted. It is, in fact, less than a decade since this Bill of Rights came into force. It came into force in 2012. It was drafted in 2009, came into force 3 years later. Indeed, as the board is aware, after the declaration was made by the Court of Appeal on the basis of the government's concession that civil partnership should be available under the Constitution, the government introduced legislation to that effect in the Cayman Islands legislature, but could not get it through. It was defeated by a single vote. Now, that course of events, in the face of the Court of Appeal's declaration and the government's concession, which then led to the governor intervening under his powers under Section 81, shows that the question of the legal recognition of the rights of same-sex couples remains a matter of considerable controversy and sensitivity in the Cayman Islands. And there is simply no evidence that there is now such a clear consensus in favor of same-sex marriage in the Cayman Islands that the living tree principle could be used to evolve or develop the what is otherwise the obvious and natural meaning of the Constitution as enacted. I would also add this, that as we shall see shortly, the living tree principle has been relied on before the Strasbourg Court in this context in a number of cases. It was relied on in Schalk and in all the subsequent cases, right down to Orlandi, decided in December 2017. And that's the reason why in those decisions you see the European Court of Human Rights looking at the evolving development of the recognition of same-sex partnerships and marriage in different Council of Europe states. And you see over the years, the number of states that recognize civil partnerships or that recognize same-sex marriage is increasing. Social attitudes are continuing to evolve. Now, my learned friend carefully spoke of Western Europe. Of course, the Council of Europe isn't just a Western European institution, it contains many Eastern European countries where social attitudes are very different, and where a number of countries that permit same-sex marriage is also very different from those in Western Europe. And the view that's been expressed on multiple occasions by the European Court of Human Rights is that in Europe, at least as at the end of 2017, there was not a sufficient consensus to warrant using the living tree principle to develop the scope of Article 12 to include same-sex marriage. And we say there's no evidential basis that has been put forward by the appellants that could lead to a different conclusion in relation to the Cayman Islands. And the final principle that I want to look at concerning the right approach to the interpretation of a constitution before I come to this particular constitution is the restrictive interpretation of provisions that restrict rights. Now, that was put in very broad terms by Mr. Fitzgerald, and at some points in his submissions he appeared to be saying that the court should strain to adopt any interpretation that would expand the scope of rights, and should only ever adopt a construction that would limit the scope of a right if it was led to conclude that was the only possible construction. We say that's not the right principle. We say there are two elements to this. The first is that the court should assume, as its starting point, that the government and the legislature intended to comply with the international law human rights obligations of the Cayman Islands. And this is a point that's developed by Lord Bingham in Rays, so that if there was alleged to be an inconsistency between the Cayman Constitution as interpreted by the Court of Appeal and the European Convention on Human Rights, or the ICCPR, both of which are international law obligations of the Cayman Islands, that would indeed be a reason for adopting a restrictive approach to interpretation. But that is not alleged to be the case here. It's accepted by the appellants, and we say rightly so, that there is no such inconsistency. So that's not a constraint. In fact, what the appellants are seeking is a ruling that this constitution goes further and gives rights that are not included in those international law obligations. Now, of course, we accept that it was open to the legislature to go further than the international law obligations. And indeed, there are some respects in which this constitution does go further. And I mentioned yesterday the fact that it gives a right to good administration, which is not found in the European Convention on Human Rights. But in my submission, it is simply impossible to interpret Section 14 of the Cayman Bill of Rights as intending to give greater rights than Section 12. And equally impossible to interpret Sections 9 and 16 as giving greater rights than Articles 8 and 14. There's just no basis for that. So that's the first aspect of it. The second aspect of it, my learned friend derives from the case of Hughes, and that's at page 1177. And it's paragraphs 34 to 35. Before we go there, can I just briefly draw to your attention at page 1193, paragraph 25. It cannot be too strongly stressed that the Constitution does not mean whatever we might wish it to mean. And then if we come to the paragraphs on which my learned friend relies, at 34 and 35 at page 1195, what these paragraphs are addressing is a situation in which a right is given by the Constitution, but there is then an exception or a restriction on that right. So you can see that 34, they say the effect of paragraph 10 is to introduce 2 exceptions to the protection made available to the people of St. Lucia by sections 5 and 120 and 5 and 16 of the Constitution. And then it explains what those exceptions are. So it's exceptions to rights. And then they say, since paragraph 10 introduces these exceptions to the rights and protections which people would otherwise have under the Constitution, it must be construed like any other derogation from constitutional guarantees. A well-known principle of construction that exceptions contained in constitutions are ordinarily to be given strict and narrow rather than broad constructions. So that's the second principle. And we submit it is not applicable here, because we do not here have a constitution that bestows a general right to marry on all, whether they are same sex or opposite sex, and then says, however, this right is not available to same sex couples. Rather, we have a constitution that defines the right to marry in terms of being a right enjoyed by those who are of marriageable age, who are not already married, and who are of the opposite sex. And that interpretation of the scope of the right is completely in line with the common law understanding of marriage. So there is no pre-existing wider right to which an exception is being reduced. Rather, what the appellants are seeking is to argue that that right should be extended in the light of evolving social mores. So that's what I wanted to say about the general applicable principles. And can I now turn to the Cayman Constitution itself? And the court already has my submission that it's not right to start by looking at sections 9 and 16 to construe a general right to marry from them, and then to treat section 14 as if it were an exception or a restriction. So if we go to the Constitution, starting at page 835, and just for the court's note, this is dealt with in our written case. It's paragraphs 22 to 28, pages 766 to 769. And the preamble is at page 846. Now, my learned friend made some comments yesterday in response to a question from Lord Sales, but with respect, Lord Sales's question was not addressed to the preamble. It was addressed to section 1 of the Bill of Rights, which the court will find at page 848. And the Bill of Rights has its own preamble, and it's notable in my submission that it refers to the right of self-determination and the right freely to determine their political status and freely pursue their economic, social and cultural development, and may for their own ends freely dispose of their natural wealth and resources without prejudice to any obligations arising out of international economic cooperation based on the principle of mutual benefit and international law. So the starting point for the Bill of Rights itself is that it is an act of self-determination, an exercise of democratic autonomy by the Cayman Islands people. And in my submission, that is important. But then when we come to section 1.
Can I just ask
yes, my lord.
about that?
Yes.
What we're looking at is, I think, an order in council,
yes,
made by the Queen,
yes,
under powers conferred by the United Kingdom statute.
yes.
and it's strictly a statutory instrument.
Yes.
Yeah.
Yes.
Yeah. So it's not this isn't an instrument created by any organ in the Cayman Islands.
No, but it's created in recognition of the right to self-determination of the Cayman Islands. And I mean, of course, the focus of this case has been on the Bill of Rights, but much of this constitution, which in fact has been subsequently amended to make this even clearer, is concerned with the establishment of developed democratic institutions within the Cayman Islands to ensure that the Cayman Islands have full autonomy over their domestic affairs. So we then come to section 1, and I emphasize this is not the preamble, this is the first substantive provision of the Bill of Rights.
And I'm sorry to interrupt you again.
Yes.
I'm just trying to understand. It's really an absolutely basic level.
Yes.
And if you look at 846, you'll see how the Constitution begins. The people of the Cayman Islands, etc.
Yes.
Affirm their intention to be. So it's a document which is drafted so as to be an expression by the people of the Cayman Islands.
Yes.
Of their own arrangement. But as we've seen, it takes.
It's my lord. It's a schedule to the statutory instrument. So if you go back to page 837, you see the Order in Council itself.
Yep.
And you can see at 838 the establishment of the Constitution.
Yeah.
So Schedule 2 shall have effect as the Constitution of the Cayman Islands from the appointed day.
Yeah.
So the effect is that the Order in Council brings into legal effect the Constitution as drafted in the schedule.
I see. Now, and we saw yesterday some documents to do with the negotiation of the Constitution, and it seems to have been a product of discussions involving chaired by an official, a lawyer at the Foreign Office, and involving our Foreign Office and also a variety of bodies from the Cayman Islands.
That's correct. Yes.
Yeah,
that's right. So that's right. It was the government, the backbench MPs, the opposition, the Human Rights Committee, and the churches of the Cayman Islands, and representatives from the Foreign Commonwealth Office. Yes.
And presumably the Foreign Office interest in this to ensure that the document is consistent with international obligations to which the UK is responsible.
That's correct, my lord. Yes. Yes.
But subject to that point, I suppose the intention is that it is indeed an expression of what's considered appropriate by the people of the Cayman Islands speaking through their representatives who were involved in its negotiation.
That's correct, my lord. I said that the Constitution had in fact been amended. It's actually been amended to make the autonomy of the Cayman Islands even more readily apparent. It's let me just give your lordships the reference. It's page 1625. Last year, there was an amendment to the Constitution, Cayman Islands Constitution Amendment Order. And if you go to 1626, you can see a new provision at section 5.5. For the avoidance of doubt, it is declared, subject to this constitution, that the cabinet possesses autonomous and exclusive capacity in domestic affairs for any matter that is not one of the following. And there are then a limited number of reserved matters.
Yes, and to clear up a point that seems to be a matter of confusion yesterday, and also in the judgment of the Chief Justice, the Cayman Islands do not form any part of the United Kingdom, do they?
Only as a matter of international law, my lord, when you're looking at it from the perspective of the UK's obligations under the European Convention on Human Rights.
Well, to be clear, they're not part of the UK, even for the purposes of the European Convention. Otherwise, an extension under Article 56 wouldn't be necessary.
Yes.
The whole rationale.
It's simply that the United Kingdom is, as it were, their representative.
Yes.
Yes. Yes.
I mean, we went into this sort of issue in relation to the sovereign bases on Cyprus in a case about 2 years ago, which some other members of the court may remember. And the whole point was, for example, if you landed in Decalia, that didn't mean you were in the United Kingdom for
Yes.
our immigration legislation.
Yes. Yes, that's correct. So can we now go back to the Constitution? We were just looking at Section 1 of the Bill of Rights. So we were on page 848. And I've made the point that this is not a preamble, it's a substantive provision. And in my submission, what you see at Section 1 is the sort of balance that I have been talking about. So first of all, this part of the Constitution, so this is specifically talking about the Bill of Rights, recognizes the distinct history, culture, Christian values, and socio-economic framework of the Cayman Islands, and it affirms the rule of law and the democratic values of human dignity, equality, and freedom. So you see references there both to the Christian values of the Cayman Islands, their unique culture, and liberty, equality, and freedom. And then importantly, at 1.2b, this part of the Constitution confirms or creates certain responsibilities of the government and corresponding rights of every person against the government. So that is the purpose of each of the articles of the Bill of Rights, to confirm or create responsibilities of the government and corresponding rights. So we are looking to individual articles to define the scope of the responsibilities and rights that are either created or confirmed. So if you look in the case of marriage, it's confirmation in the sense that, of course, there was a common law right to marry in the Cayman Islands, which then became a statutory right to marry before it was elevated now to a constitutional right to marry. And the scope of that right is as set out in the relevant section, section 14. So that's the function that we would expect section 14 to be performing. So I now then want to turn to section 14 itself. Which is at page 859. Headed Marriage. Government shall respect the right of every unmarried man and woman of marriageable age as determined by law, freely to marry a person of the opposite sex and found a family. Now, in my submission, the meaning of that provision is absolutely clear, beyond any reasonable doubt. It is confirming the existence of the right to marry defined in those terms, and the responsibility of the government to respect that right. The notion of respecting rights is one that this court will be familiar with from Strasbourg jurisprudence. It tends to refer particularly to positive obligations on the state to facilitate the enjoyment of particular rights. So as here, respecting the right to marry would include things like ensuring that there was a registrar available so that a marriage could actually be registered, which would require positive action by the state. And the right is carefully defined by reference to three conditions. First, the parties must be unmarried. So there is no right to polygamous marriage in the Cayman Islands. Now, as a matter of fact, all of the arguments that my learned friend makes in favour of same-sex marriage could be made in favour of polygamous marriage. It is a matter between consenting adults. There are some religious faiths that have a strong belief in polygamous marriage. On his argument, the Cayman Islands would be under an obligation under Section 9 or Section 9 plus 16 or Section 10 or Section 10 plus 16 to permit polygamous marriage unless it could demonstrate that there was an objective and proportionate justification for not doing so. Now, in my submission, that is an outlandish interpretation of the Bill of Rights, clearly not the intention. And yet there is no substantive difference between the argument that seeks to derive a right to polygamous marriage from Section 9 or 10 or 16 in the face of Section 14 and the same argument being mounted by my learned friend. So that is the first condition. The second is that they must be of marriageable age, and the question of what constitutes marriageable age is expressly delegated to the legislature. And the third is a person of the opposite sex. And those are the three conditions that define the scope of this right. Now, my learned friend conceded yesterday that his appeal must fail if Section 14(1) included the word only. The government shall respect the right only of every unmarried man and woman of marriageable age freely to marry a person of the opposite sex. Now, in my submission, there is no difference between this provision including the word only and the provision without that word. It's particularly striking that he made that concession because he has, at other parts of his submission, particularly when dealing with the Strasbourg case law, accepted that there's a distinction between Article 12 of the Convention and Section 14, in the sense, as he said yesterday, Section 14 could never be interpreted to include same-sex marriage. And indeed, in a bold move, he sought to rely on that as being a reason why, in the face of that unequivocal intention, you ought to derive that right from other provisions of the Constitution. But in my submission, the fact that he makes that submission shows what's wrong with his position in relation to the word only. Because in fact, it is crystal clear that these are the conditions on which the right to marriage arises, and the use of only is unnecessary. On Mr. Fitzgerald's case, the purpose served by Section 14 is a puzzling one. because he says that the right to both same-sex and, one must assume, opposite-sex couples as well to marry can be derived from Section 9, the right to respect for private and family life. If that's so, why do we have Section 14 at all? And more specifically, why do we have Section 14 defined in terms of conditions which are in fact unconstitutional? On his case, the legislature has here, in one breath, enacted a provision giving a general right to marry to both same-sex and opposite-sex couples, and a provision which appears to limit that right only to opposite-sex couples in a way that's actively misleading. Why would the legislature seek to do that? Now, his only explanation is that the intention here should be taken to be to protect traditional opposite-sex marriage against abolition by the state or the imposition of hurdles that would make it disproportionately difficult to enter into. Well, with great respect to him, that doesn't make any sense at all, because on his case, you would derive that right from Section 9 anyway. So why have Section 14? He also seeks to detach the right to found a family as if it were a separate right and to mount an argument on that. In my submission, that is a misinterpretation of Section 14.1. Section 14.1 is a single composite right on the conditions here stated to marry and found a family. The language, of course, comes from the European Convention, Article 12. The right to found a family has never been regarded as a substantive separate right under Article 12. My learned junior was up all night last night and has failed to find a single case in which the Strasbourg court has ever found a breach of the right to found a family. There have been some cases where there's been argument on the question, but there's never been found to be a breach. The Strasbourg approach has always been to treat everything relating to the enjoyment of family life as falling within Article 8, and the right to marry and found a family being no more than the very narrow point that the foundation of a family is the central purpose of marriage. So we say he gets nothing from that. Now we then turn to Section 14.3, and in my submission, this is important when you're looking at the coherent interpretation of this constitution as a whole. So Section 14.3 is the provision that permits limitations on the right to marry. Nothing in any law or done under its authority shall be held to contravene subsection 1 to the extent that the law makes provision that is reasonably justifiable in a democratic society, and then 3 purposes are set out. The first is in the interests of public order, public morality, or public health. The third is protecting the rights and freedoms of others, and both of these are familiar purposes that you'll find in other provisions under this constitution. But 14.3b is unique to Section 14. The purpose here is for regulating in the public interest the procedures and modalities of marriage. That is a purpose for which the right to marry may be limited. And one can understand why. So, for example, it would give the power to say that you could only get married either in a religious building or in a registry office, as used to be the law in the United Kingdom until it was relaxed some years ago. But that is not a permissible reason for limiting the right to respect for private and family life under Section 9, or the right to freedom of conscience and religion under Section 10, or the right not to suffer discrimination under Section 16. So if we look, let's just look for a moment at Section 9, and you'll see what I mean. It's at page 855. So we have a similar structure here where the right is at Section 9.1, respect for private and family life, home and correspondence. And then the purposes for which that right may be restricted at subsection 3. And you can see that the first of these more or less equates to Section 14.3a. The second equates to 14.3c. The other three purposes listed here don't have an equivalent in Section 14. And there is no equivalent of Section 14.3b. Now, the implications of that for Mr. Fitzgerald's argument are quite startling, because what that implies is, on his case, Section 14 is a regime that only applies to opposite-sex marriage. Doesn't apply, he says, to same-sex marriage. That's dealt with under Section 9 or 9+16. So in his case, the state here has introduced a right to opposite-sex marriage that may be limited for a purpose set out at 14.3b, but at the same time has introduced a wider right to same-sex marriage, which it doesn't have the power to limit for the purpose under 14.3b. In other words, his argument involves the startling conclusion that the intention here was to have a broader right to same-sex marriage than to opposite-sex marriage. Now, we say that is a classic example of the kind of incoherence and internal inconsistency which is to be avoided, whether you're interpreting a legal instrument or a constitution. It's a clear pointer that you're misconstruing the intention of this document. Now, Mr. Fitzgerald sought to address this difficulty in two ways. First of all, he said, oh, well, Section 14.3 doesn't refer to a member of the opposite sex. Well, that, with respect, is a bad point, because Section 14.3 refers to a contravention of subsection 1. So it is directly referring back and incorporating the right as defined at Section 14.1, which is the right to marry a person of the opposite sex. So indeed, it does refer to the opposite sex. It does so by incorporating Section 14.1. It's talking about an infringement of the right as defined in 14.1. His second answer was to say, oh, well, Section 9 has its own subsection 3. And the same is true of Section 10 and Section 16. But none of those provisions have an equivalent of Section 14.3b. My lords, my ladies, that might be a convenient moment for our short break.
Thank you very much, Ms. Rose. In that case, we'll adjourn now and resume in about 5 minutes' time. I think we're ready to resume now. Ms. Rose.
Thank you very much. So, in summary, we submit that Section 14 should be understood as the section intended comprehensively to define the scope of the constitutionally protected right to marry. This, of course, does not preclude Parliament from choosing to give wider rights in the future. The Cayman Parliament could permit same-sex marriage or polygamous marriage if it wished to do so, but there is no right to those forms of marriage under this constitution. And the fact that they're not available under this constitution does not have to be objectively justified either as a restriction on a right or as discrimination within the ambit of a right. If we then go to section, I've dealt with section 9, but can I now go to section 16 dealing with discrimination? And I agree with Mr. Fitzgerald that the question is whether or not the less favourable treatment or inequality of treatment is within the ambit of a right. And if the Court of Appeal meant it when they said violation, that was indeed not correct. It is within the ambit of a right. It doesn't have to be shown to be a violation of another right. Now, my learned friend mounted an alternative argument based on section 16(7). And he said that section 2 of the marriage law is a restriction for the purposes of section 14(1) and therefore has to be justified under section 16(7). With respect, this is a misreading of section 16(7). What this provision is doing, if you go back over the page to 862, you can see at section 16(3) that there is a general provision which permits justifiable discrimination on grounds of defence, public safety, public order, public morality, or public health. So those are the bases under section 16 itself on which discrimination may be justified. But then at section 16(7, the Constitution makes clear that if you're complaining of discrimination within the ambit of any particular other right, which of course you have to be, then the purposes for which that right that you're relying on may be restricted can also be relied on as a justification for discrimination in the enjoyment of that right. So, for example, if your complaint is that you're suffering discrimination in relation to your right to marry, let's say there was a provision that said that certain denominations could marry in a church but nowhere else, but other denominations could marry in the open air. You could complain of discrimination under section 14, and one of the legitimate aims that the state could rely on would be the aim under 14(3)(b), the modalities and procedures of marriage purpose. That's all it's saying. Now, it has no application here because, as you can see from 16(7) itself, subsection 1 is without prejudice to any restriction on the rights and freedoms guaranteed by the relevant sections if that restriction would be a restriction authorized for the purposes of that section. So it only applies where there's a restriction on the rights and freedoms guaranteed by the other sections. Now, section 2 of the marriage law does not restrict the right guaranteed under section 14. It's coterminous with the right guaranteed under section 14. So there is nothing on which section 16(7) can bite. My learned friend also relies on section 10. In our submission, the objection to this is exactly the same as that in relation to sections 9 and 16, that marriage is dealt with comprehensively under section 14, and you cannot read in a right to marry in any other article. Now, if my learned friend doesn't succeed under 9 and 16, his reliance on 10 in our submission is deeply unpromising, because section 10 is specifically about freedom of conscience and religion, and it protects the manifestation of beliefs only in a limited way to manifest and propagate his or her religion or belief in worship, teaching, practice, observance, and day of worship. And in our submission, there is no reasonable basis for interpreting that to include a person who says, well, I believe in marriage as an institution, being able to say that that then gives them a right to insist that the state legislate to permit them to marry. That is not the scope of section 10. So in our submission, this is a case where section 14 is properly to be read as the provision that deals with marriage, and the more general protections that my learned friend relies on, whether it's section 9, section 10, or either of those read with section 16, should not be read so as to undermine or contradict the provisions of section 14. Since section 14 confirms a right to marry subject to specific conditions, it is wrong in principle to infer a wider right to marry from the right to respect for private and family life. And we do submit, as we did below, that on the appellant's case, section 14 is both OTOs, it serves no purpose, and misleading and incomplete as a description of rights. So that, we say, is the construction of the Constitution looking simply at the document itself read as a whole. We submit that the correctness of this approach becomes even more apparent when you look at the Cayman Islands Bill of Rights in its broader context, and in particular in the context of the international law obligations of the Cayman Islands under both the European Convention and the ICCPR. Because the interpretation of the Bill of Rights that I have just advanced is exactly the same as that which has been consistently adopted in relation to strikingly similar provisions under both of those instruments on multiple occasions. And we submit that it would be very surprising if this very similar document, clearly modelled on those human rights instruments, were to be held to have so radically different and more extensive a meaning than they do. And particularly surprising when, in one respect, the wording is more clear in relation to this Constitution, because it actually includes the term of the opposite sex. So that then brings me to the Convention case law. This is dealt with in our written case. For your note, it's paragraphs 30 to 38 of our written case, pages 769 to 773. And the reasoning of the Court of Appeal on this, which we gratefully adopt, starts at paragraph 16, page 140, then continues at paragraphs 42 to 64, pages 149 to 156. The position of Mr. Fitzgerald is set out at 158 to 9, paragraphs 69 to 73, and the court's conclusions are at paragraphs 101 to 105, pages 168 to 9. And we submit that the Court of Appeal's approach is correct. The first point is that the approach taken by the Strasbourg Court of treating Article 12 as the lex specialis in relation to marriage goes back a long way, to at least 1985 and the Khan case, which you have in your bundle at page 1221. This was a complaint brought under Article 9 of the Convention, a complaint of a violation of the freedom to manifest religious belief. And as you can see at page 1222, the applicant was a British citizen and a Muslim who wished to marry a girl aged under 16. And his argument was that this was in accordance with his religious faith, and that the age of consent and the risk of criminal prosecution were an interference with his right to freedom of religion. And you can see the complaints at page 122, mounted under Article 9, Article 12, and Article 14. And the reasoning of the Commission is at 1223. It's true that Article 9 secures to everyone the right to freedom of thought, conscience, and religion, and to manifest their religion or belief in worship, teaching, practice, or observance. However, the term practice, as employed in Article 9, Para 1, does not cover each and every act which may be motivated or influenced by a religion or belief. While the applicant's religion may allow the marriage of girls at the age of 12, marriage cannot be considered simply as a form of expression of thought, conscience, or religion, but is governed specifically by Article 12. And then again, you see in the paragraph below that the matter is considered exclusively under Article 12. The applicant's girlfriend was therefore not of marriageable age required by internal law. Since the right to marry guaranteed under Article 12 is subject to internal laws, the Commission concludes in the circumstances of the case there is no appearance of a violation of rights under the Convention, and in particular Article 9 and 12. So already at that early stage you see the idea of the lex specialis, that this is specifically within the remit of Article 12 and therefore not an Article 9 issue. We see the same thing, this again predates the Cayman Constitution, tab 89, the case of RNF in the UK. This is page 3793. And this dates to 2006. So this is at the time when work is being done on the draft that would ultimately become the Cayman Bill of Rights. And the issue here was a married couple, one partner underwent gender reassignment. So they were then both legally of the same sex, and they were required to divorce in order to get a gender recognition certificate. They were then able to have a civil partnership, but they could not remarry. And you can see the issue at page 3794 summarized. And if you go to page 3806, you can see the treatment of Article 12. Same-sex marriages, this is about 2/3 of the way down the page. Same-sex marriages are not permitted. Article 12 of the Convention similarly enshrines the traditional concept of marriage as being between a man and a woman. While it's true there are a number of contracting states which have extended marriage to same-sex partners, this reflects their own vision of the role of marriage in their societies, does not, perhaps regrettably to many, flow from an interpretation of the fundamental right as laid down by the contracting states in the Convention. And then if you go back to 3804, this is where the court is looking at the matter under Article 8. you can see at the top paragraph where they're discussing the unfortunate position in which these applicants have been placed, and they say, however, it must be taken into account, as the government have asserted, that Article 12 is the lex specialis for the right to marry. So it's the same approach, even though there is clearly an interference with the enjoyment of private and family life here, on any normal use of the term, the court deals with it under Article 12. We then come to Schalk at page 1556. This was decided in 2010, so that's shortly after the Constitution had been finalised, but before it had come into effect. And if you go to page 1562, under the heading Comparative Law, paragraph 24, you'll see there's a reference to Article 9 of the Charter of Fundamental Rights of the European Union. And as we'll see in a minute, the court makes the point that Article 9 of the Charter, which is of course a much more recent instrument than the Convention, does not include the reference to a man and a woman that is found in Article 12 of the Convention. It appears to be a broader right that would encompass same-sex marriage. Now, the reason I draw that to the court's attention is, of course, that's an instrument from 2000. The Cayman Islands could have decided to adopt wording for the right to marry, equivalent to that under Article 9 of the EU Charter. But they didn't. Instead, not only did they choose wording derived from Article 12 of the Convention, but they made its meaning even clearer. Then the analysis starts at page 1567, paragraph 49. I draw attention simply at 49 to the fact that the right to marry and found a family is treated there as a single right, not as two separate rights. Paragraph 49. Then at page 1568, paragraph 54, we come on to the application in the present case. And at paragraphs 54 and 55, there is discussion of the meaning of the language, the right of a man and a woman. Now, my learned friend seems to be seeking to challenge this analysis by reference to an article that was produced on Monday, written by a sociologist called Mr. Johnson. Now, we've had no opportunity to consider whether what Mr. Johnson says about the travaux préparatoires to the Universal Declaration is or is not correct. But in my submission, it matters not whether he is or isn't correct. What matters is what the European Court of Human Rights has said on this issue. And it said it not only in 2010, but repeatedly more recently, as the court knows. And the article from Mr. Johnson, I don't know why it was only produced on Monday, because it was written in 2015. So it in fact predates the reaffirmation of the principle in Schalk in both Oliari and Orlandi by the European Court. So that's 54 and 55. And the discussion of the right to found a family is at 56. As regards the connection between the right to marry and the right to found a family, the court's already held that the inability of any couple to conceive or parent a child cannot be regarded as per se removing the right to marry. However, this finding does not allow any conclusion regarding the issue of same-sex marriage. So the suggestion that the right to found a family is in some way relevant here is expressly rejected by the court in that paragraph. And then at 57, the court says this: in any case, the applicants did not rely mainly on the textual interpretation of Article 12. In essence, they relied on the court's case law, according to which the convention is a living instrument, which is to be interpreted in present-day conditions. In the applicant's contention, Article 12 should in present-day conditions be read as granting same-sex couples access to marriage. Now, that is precisely the argument that is mounted in this case by Mr. Fitzgerald. And in my submission, it's also significant when you consider the reasoning of the court, because this is not a case in which a decision is being made by the court based on margin of appreciation, or whether or not extending marriage only to opposite-sex couples is justifiable. It's a question of the interpretation of Article 12, where the court starts with the text, then considers the living instrument or living tree principle, and in that context asks whether there is now such a consensus amongst Council of Europe countries that it's appropriate to adopt a different interpretation, and concludes that it is not. It's about interpretation. It's not about margin of appreciation. It's not about justification. And then we see that clearly at paragraph 58, where the living instrument argument is rejected on the basis that there isn't a European consensus regarding same-sex marriage. Then at paragraph 60, the court considers the implication of Article 9 of the Charter. And then at 61, it says the court would no longer consider that the right to marry must in all circumstances be limited to marriage between two persons of the opposite sex. Cannot be said Article 12 is inapplicable to the complaint. However, as matters stand, the question whether or not to allow same-sex marriage is left to regulation by the national law of the contracting state. Now, nowhere is it said by the court that they would have interpreted the convention as giving a right to same-sex marriage under Article 8+14, but for the fact that it was possible at some point in the future that Article 12 could be developed to encompass same-sex marriage. That is an argument that Mr. Fitzgerald created yesterday, but it finds no support anywhere in the case law. Indeed, in my submission, it's inconsistent with the reasoning. The reason why the court concluded that Article 12 didn't include same-sex marriage was simply given higher up the page. So the conclusion is at 63 that Article 12 does not impose an obligation on the government to grant a same-sex couple access to marriage. And then we come on to consider Article 8+14. And you see the parties' submissions if you go to page 1572, paragraph 76. And this submission is exactly the same as the submission made by Mr. Fitzgerald in this case. The applicants maintained that the heart of their complaint was that they were discriminated against as a same-sex couple. Agreeing with the government on the applicability of Article 14 in conjunction with Article 8, they asserted that just like differences based on sex, differences based on sexual orientation required particularly serious reasons for justification. In the applicant's contention, the government had failed to submit any such reasons for excluding them from access to marriage. And you'll see the language used there, exclusion from access to marriage, is exactly the same as the way that the argument is put by Mr. Fitzgerald and put here under Articles 8 and 14. And we see the court's assessment starting at 1574. And first of all, the court considers the applicability of Article 8 and 14. And it concludes at paragraph 95, at 1575, that the facts of the case fall within the notion of private life and family life. We then go to paragraph 100 at page 1576. And here the court identifies two complaints of discrimination being made. The applicants argued they were discriminated against as a same-sex couple, first, in that they still did not have access to marriage, and secondly, in that no alternative means of legal recognition were available to them until the entry into force of the Registered Partnership Act. So there's a complaint of discrimination both about marriage and both about civil partnership. And the court considers them separately and on the basis of different legal reasoning. In relation to marriage, the court says this at 101. Insofar as the applicants appear to contend that if not included in Article 12, the right to marry might be derived from Article 14 in conjunction with Article 8, the court is unable to share their view. So this is not about justification or margin of appreciation, it's a point of construction. It reiterates that the convention is to be read as a whole, and its articles should therefore be construed in harmony with one another. Having regard to the conclusion reached above, namely that Article 12 does not impose an obligation on contracting states to grant same-sex couples access to marriage, Article 14, in conjunction with Article 8, a provision of more general purpose and scope, cannot be interpreted as imposing such an obligation either. Now, we say that reasoning is exactly the same as the reasoning of the Cayman government in this case, and it is applicable as the right interpretation of this Bill of Rights for exactly the same reasons that it is the European Convention. Indeed, we say this case is stronger because of the section 14.3b point that I made before the short break. But the essential point there, we say, is nothing to do with margin of appreciation, nothing to do with justification. It's a question of interpretation of the convention read as a whole. And it has nothing to do with the idea that at some future date, Article 12 might be expanded. They then turn to the second limb, the lack of alternative recognition at 102. And it's in that context that they consider questions of margin of appreciation. So margin of appreciation is regarded as relevant in relation to the question of the timing of the availability of civil partnership, because civil partnership is not dealt with under Article 12. But that is not the basis for the reasoning in relation to marriage. Now that, we say, is the principle established by the European Court of Human Rights in Schalk, to which it has adhered in its subsequent case law. Unless the court wishes me to, I don't propose to go to the subsequent cases in detail, but can I give you the relevant references? Hämäläinen, this is from 2014. That's at page 1143. And the Article 12 analysis is at page 1164, paragraph 96, reiterating the decision in Schalk. Then Oliari is at tab 19, page 1459, and that's from 2017. And in this case, the court examined the question of civil partnership under Article 8 and marriage under Article 12. At paragraph 189, you can see the living instrument argument was run again, because of course we're now 7 years further down the line after Schalk, so there's another attempt to run the living instrument argument, and it was rejected at paragraph 191 on the basis that there still wasn't a consensus. And the lex specialis point was dealt with at paragraphs 193 to 4. And strikingly, the conclusion that was reached by the court in Oliari was that the claim in relation to marriage was manifestly ill-founded. Wasn't simply wrong on the merits, but was manifestly ill-founded. Once again, nothing to do with justification, nothing to do with margin of appreciation, all about interpretation of the convention as a whole. Then Orlandi, that's at page 3632, a decision from December 2017. And this is about a refusal by the state to recognize a same-sex marriage that had been contracted abroad. And you'll notice in this case, the European Court of Human Rights specifically refers to Obergefell. So they're well aware of the approach that's been taken by the US Supreme Court. That's at paragraph 115. And the court's assessment under Article 8 is at page 3671. Paragraphs 192 and 194 deal with civil partnerships. 209 to 10 find a breach in relation to civil partnership. But no breach in relation to marriage. So that, we say, is the clear and consistent case law of the European Court of Human Rights, and it strongly supports the interpretation of the Bill of Rights found by the Court of Appeal in this case. The same is true of the ICCPR, and that's the decision in Joslin, which you have at tab 14. We can just briefly look at that. It's page 1202. This is a decision from 2002. Just for your note, our written case wrongly describes this as 1999. 1999 was the date when the application was submitted, but the decision is from 2002. And you can see the complaint at paragraph 3, the failure to provide in New Zealand for same-sex marriage. And you can see that they claim violations of Article 26, the right to equality, Article 16, which is dignity, Article 17, which is private and family life, and Article 23, which is marriage. And the state's argument you can see at 1207, and it relies on Article 23, which defines marriage in the same terms that Article 12 of the European Convention does. The state's overarching argument is that the terms of Article 23(2) clearly envisage marriage may properly be defined in terms of couples of opposite sexes. Ordinary meaning of the word to marry refers to couples of opposite sexes. It's the only substantive right expressed in gender-specific terms of men and women. This contextual reading is strengthened by the word spouse, and so forth. And then at 4.5, the state party emphasizes that the specific terms of Article 23, paragraph 2, in clearly referring to couples of different sex, must influence the interpretation of the other convention rights to be invoked, following the interpretative maxim generalia specialibus non derogant, to the effect general provisions should not detract from the meaning of specific provisions. The specific meaning of Article 23(2) excludes a contrary interpretation. So there, in the context of an international human rights convention, you see the generalia specialibus principle rather than a lex specialis. And your ladyship will note that essentially they're just labels for the same point, that you must read the document as a whole and coherently and with internal consistency. And that argument is accepted by the court. We go to the decision.
In truth, I think it was dealing not with a conflict between rights, but between the right itself, wasn't it? It is not saying.
It's saying that given the provisions of Article 23.2 defining marriage as opposite sex, then the other more general provisions of the Convention relied on, including dignity, private and family life, and so on, can't have a wider meaning.
Yes.
That's exactly the same point.
Yep.
So the other convention rights invoked are private and family life and dignity and equality.
Yes, but not non-discrimination.
Well, yes, my lady, yes, non-discrimination, Article 26.
26.
Yes. And then the decision starts at page 1213. It's very brief, but in my submission clearly accepts the submission we've just been looking at. If you look at 1214, first complete paragraph, in fact, above, just simply above that, if you look at the very bottom of 1213, the author's essential claim is that the covenant obligates states parties to confer on homosexual couples the capacity to marry, and that by denying the authors this capacity, the state party violates their rights under Articles 16, 17, 23, and 26, 26 being non-discrimination. The committee notes that 23.2 expressly addresses the issue of the right to marry. Given the existence of a specific provision in the covenant on the right to marriage, any claim that this right has been violated must be considered in the light of this provision. So that's the point, that notwithstanding the reliance on private and family life and equality and so on, they say you must look at it under Article 23.2. And then they have the point that they say that is only for opposite sex marriage. And then at 8.3, in light of the scope of the right to marry under 23.2, the committee cannot find that by mere refusal to provide for marriage between homosexual couples, the state party has violated the rights of the authors under 16, 17, 23, or 26. So although briefly expressed in my submission, it is the same reasoning as that which you find in much more detail in Schalt.
Yes, but I would still prefer to think of it not as a normal principle of commercial documents, the interpretation of normal commercial documents, but as something quite singular and peculiar to constitution, and therefore as having a wider meaning.
Yes, I understand that, my lady. So just to sum up the submission that we make in this case is that the Constitution we accept should be interpreted to be consistent with the Cayman Islands obligations under both the European Convention and the ICCPR, at least as insofar as such a construction is possible. And it's clear that this constitution, interpreted as we say it should be constitution, is consistent with those instruments. So this is not a case where there is any need to adopt a strained or restricted construction of the Constitution. Not only that, we submit that the similar wording and structure of the Cayman Bill of Rights, when compared with the European Convention in particular, invite a similar interpretation. One must assume that the provisions of the European Convention were very familiar to the drafters of the Cayman Constitution. They were, although not followed slavishly, they were the principal model which underlay the Bill of Rights, and you can see their influence on every page of that document. The only material difference between Section 14 and Article 12 is the inclusion of the words a member of the opposite sex in Section 14. Now, that can be easily understood as an exercise of the choice referred to by the European Court of Human Rights in Schalk itself, because what you have under Article 12 is a provision that says there's a right for men and women to marry in accordance with the provisions of national law. And you have the court there saying, well, it's a matter for the national legislature to decide this question. There's no obligation to have same-sex marriage. And then what you have is the Cayman Islands exercising that choice and making it clear how they've exercised it. Of course, the Cayman Islands could have made a different choice, and they had before them at least two different types of models. One would have been the Article 9 model from the EU Charter. Another would have been to adopt the model used in the United States or South Africa and Canada, where you don't have a definition of marriage at all, but you simply have an overarching principle of equality, which applies to all laws. But those were not the models that the Cayman Islands chose to adopt. They chose a model based on the European Convention and on the ICCPR. To succeed in our submission, the appellants have to show that the intention of the drafter here was to confer rights on same-sex couples to marry that went beyond the rights conferred by the European Convention or the ICCPR. In the light of the material I've shown the court, we submit that is an impossible proposition. We submit that is the end of this appeal, but we do also rely on the negotiation history. Now, we do submit that Section 14 is crystal clear, and in the light of all of the materials you've seen, so is the rest of the Constitution. But in case there were any conceivable doubt about the proper ambit of Section 16 here, the right not to suffer discrimination, we do submit that the negotiating history makes it clear that there was no intention that the right not to suffer discrimination within the ambit of the Bill of Rights was to confer a right to same-sex marriage, which had not been included in Section 14. Now, the Court of Appeal's finding on this is at paragraph 114, page 171 of the judgment, and it's dealt with in our written case at paragraphs 39 to 53, that's pages 773 to 778. And we have referred to the case law on the admissibility of negotiation material. Now, I don't understand from yesterday that it's actually in dispute that this material is admissible. All that's said by my learned friend is that it should be treated with caution. The case is the Makwanyane case, which is at page 4131. And in particular, you can see the discussion starts at page 4140, paragraph 16. I don't propose to, it goes all the way down to paragraph 20 at page 4143. Now, the key passages are at pages 503 and 506 of the electronic bundle. These are the passages from the negotiation. Now, my Lord Sales asked the question, how the drafts were dealt with. My instructions are that the first draft of the Constitution was produced after consultation within the Cayman Islands on behalf of the Cayman Islands government, and that subsequent drafts were then produced by the representatives of the Foreign and Commonwealth Office following the negotiation rounds.
If I can
Yes.
just interject, Ms. Rose. I'm slightly nervous about relying on the South African authority for the point, but I think one can see in Matadine that Lord Hoffman made it clear that the historical background was relevant to interpretation. And in that case itself, he went into quite a lot of detail about how the relevant text arrived from revolutionary Paris in 1793, and they got it. They didn't know at the time that Robespierre's administration had fallen because of the delay in getting news to Mauritius or les îles Maurice, and so it's actually Matadine is quite a striking example of looking at the historical background to a constitutional provision.
My lord, I'm grateful. I only wish that we had Travaux as exciting as Mauritius did. So if we just go, the key passages, as I say, are at 503 and 506. So this is from the final round of negotiations. And they are discussing here the wording of section 16. And at page 125, you can see that concerns are being expressed by one of the pastors who was there from the Cayman Islands about the width of section 16, and it's being suggested that maybe there should be more qualifiers to it. And the chairman addresses that starting at page 126, and he says, well, there already are qualifiers in section 16, and he points out the ability to have a proportionate justification for discrimination. And then at 127, he says, I think the way it is at the moment, and bearing in mind also that subsection 1 has been qualified to refer only to the rights under this part of the Constitution, so you know that the boundaries of this section is, so you know what the boundaries of this section are going to be. Just as an example, one of the other rights is marriage. Now, marriage is so defined in this text without peradventure that marriage can only be between an unmarried man and an unmarried woman. It can't be anything else. So this doesn't make a difference. So that's a clear statement there from the chairman of the committee during the negotiation that section 16 cannot bite because there is a clear definition of the scope of marriage as only between an unmarried man and an unmarried woman. And that's being said to allay the concerns of the Cayman churches. And then if we go on to 506, internal page 13, at the bottom of the page, you can see that Sarah Collins makes a statement, and she is a representative of the Cayman Islands Human Rights Committee. And she is also dealing with section 16 and saying it shouldn't be narrowed. And she makes the point that the Cayman Islands Human Rights Committee has made compromises already. And she says, if we go to page 15, she says it's helpful to consider the background to this process because we also have made compromises. And we made these compromises designed specifically to address, we hope, the concern of the churches associations, which were to ensure that no right to marry would be conferred on gays and lesbians, and to ensure no rights would be applied horizontally. For those reasons, those matters are dealt with specifically and comprehensively in the Constitution. These concerns have been addressed. They do not remain, and there is therefore no remaining concern to which anyone can point which suggests this further compromise is necessary or reasonable. So we say that that material is of some relevance if this court were in any doubt about the scope of section 16. My lords, if I can then relatively briefly address the remaining arguments that were advanced.
Can I just ask you, is there no
Yes.
document which is a report of a rapporteur or something which summarizes the decisions that were made at the time of drafting in these meetings? We've got the transcript, but how do we know that that's the consensus of the drafting meeting?
My lady,
I
I'm not aware of there being any such document.
know there's a note attached in the annex to the skeleton argument.
That was prepared.
Deputy
Yes, that was prepared for the purposes of the Court of Appeal. That short note.
Right.
Yeah.
So that short note, is it an agreed document? No, it can't be.
I don't think so. No, my lady.
No. So, I mean, this is just a couple of comments out of the transcript.
That's right. Yes. Yes. Your ladyship will note that this is not at the forefront of my argument. We say that the most that it does is to give reassurance that the rest of the argument is correct, but primarily,
yes, you've already said the
yes,
appeal has ended on your case already.
that's right. Yes. Yeah.
Thank you.
Can I then relatively briefly address the remaining arguments that were advanced by the appellants in support of their appeal? First of all, they dealt with case law from other common law jurisdictions. So that's South Africa, the United States, and Canada, and also, of course, Bermuda. This is dealt with by the Court of Appeal at paragraphs 82 to 89 and 110 to 113. That's pages 162 to 165 and 170 to 171. And again, we adopt this reasoning. We say it's entirely correct. We deal with it in our written case, paragraphs 101 to 124, pages 793 to 801. And the short point is that all of these are jurisdictions in which there was no constitutionally defined right to marry, and in which there was, let alone one with an opposite sex limitation, and in which there was an overarching right to equality and equal treatment before the law, a freestanding right to equality. And neither of those are features of the Cayman Islands Constitution. And that again, of course, takes us back to Matadine, where the point is made by Lord Hoffman that it's not enough to say equality is an axiom of rational behaviour. You've got to look at the way that equality is treated by a specific constitution. And the model that you find, the constitutional model that you find in the case law that my learned friend relies on, is not the constitutional model that was chosen by the Cayman Islands. The same point applies to the Inter-American Court of Human Rights advisory opinion. You'll see that in that case, there is a right to marry, and it is expressly made subject to the principle of non-discrimination. So that, again, is a very significant difference from the Cayman Islands Constitution. Now, my learned friend also relies on the two recent Northern Ireland decisions, Re-Close and Re-X. Those are dealt with in our written case at paragraph 110, page 797. I do just want to look at Re-Close. This is at page 3849. We do say this is rather an oddity as a decision, because it seems to have proceeded on the basis of a concession that in our submission was wrongly made. And you can see if we go to paragraph 41, 3845. So this is the legal analysis. What the court says here is, applying that guidance, we consider that the jurisprudence of the European Court of Human Rights makes it clear that Article 12 does not establish a right to same-sex marriage. Yes, that's correct. Secondly, the case law establishes same-sex couples in loving relationships have rights under Article 8 in respect to private and family life. Yes, That's correct. Article 8 cannot, however, supply what Article 12, the lex specialis, does not supply, and cannot therefore provide a means of establishing a right to same-sex marriage. That, we say, is also correct. But then they say this: thirdly, the issue of how to recognize same-sex relationships is within the ambit of Articles 8 and 12, and therefore a matter to which Article 14 of the Convention applies, and then states enjoy a margin of appreciation on the application of discrimination caught by Article 14. The questions in this appeal are therefore whether intervention by a domestic court is appropriate, whether that intervention should include a determination that the prohibition of same-sex marriage violated rights under Article 14. So, although the court correctly perceives that you can't derive a right to same-sex marriage from Article 8, they seem to think you can derive it from Article 14. But that is contrary to the decision in Schalk and the subsequent decisions of the European Court of Human Rights, because in Schalk, there wasn't simply a rejection of a claim under Article 8. There was a rejection of a claim under Article 8 and Article 14 on the basis that they could not be construed as applying to marriage given the provisions of Article 12, the lex specialis. So we say that is the error in the reasoning here, and it leads the court into a justification analysis, which in our submission didn't arise. And it may be because of the concession that was made, which you can see at paragraph 47. It doesn't seem to have been being disputed that it was within the ambit of Articles 8 and 12, and that therefore Article 14 applied. So we say that the case is with respect, wrongly decided, and decided on the basis of an inaccurate concession. Of course, it's also the case that it is interpreting the Human Rights Act. It's not interpreting a constitution that includes the express terms of Section 14 relating to members of the opposite sex. My learned friend also relied on Steinfeld, but as was pointed out in an argument yesterday, Steinfeld is a case concerned with civil partnerships, not with same-sex marriage. And it's clear from Schalk and Oliari and Orlandi that discrimination in relation to civil partnerships does indeed fall within the ambit of Article 8 and Article 14, because it is not within the scope of Article 12. My learned friend also relies on Goodwin. I confess to finding their argument based on Goodwin somewhat opaque, but it appears to be an argument that the Bill of Rights doesn't comply with the convention because it doesn't include a right to transgender marriage. The answer to that was given an argument yesterday by my Lord Sales, that the reasoning in Goodwin is that applying the living tree principle, it should now be recognized that a person may change their sex, their gender, that you can no longer define sex and gender in purely biological terms. And that's set out at paragraphs 99 and 100 of Goodwin. That's page 1078. And that's the basis for the conclusion in Goodwin that marriage should be extended to a couple where one member has changed their sex. Now, the question of whether that reasoning is applicable in the Cayman Islands wouldn't go to the terms of the Constitution, it would go to the marriage law. The question would be whether, properly interpreted, the marriage law should be taken as encompassing a marriage between a trans man and a woman, as well as a cis man and a woman. That's not a question that arises in these proceedings, and I have no submissions to make on it, but that has no bearing on the issue before this board today. I've dealt already with my learned friend's submissions on section 16.7, which we say were based on the erroneous premise that section 2 of the marriage law restricted a right under section 14(1). It does not. He also made a point based on the pending judicial review of the Civil Partnerships Act in the Cayman Islands. Now, we submit that this has no materiality to the issue before this court. The position is that there is extant a declaration of the Court of Appeal, which has not been appealed, indeed was based on a concession made by the Cayman Islands government, that the Cayman Islands must provide legal protection equivalent to marriage for same-sex couples. Now, there is a challenge to the legislation that was enacted by the governor under Section 81. The argument is essentially whether complying with obligations under the European Convention on Human Rights constitutes external affairs, falling within the scope of the governor's powers. Now, I have no comment to make on the merits of that claim, save to say that the Cayman Islands government is resisting it. But if it were to succeed, the obligation to legislate would remain pursuant to the declaration. And if there remained difficulties in getting legislation through the Cayman Islands Parliament, the United Kingdom could legislate through an order in council. So whether or not this claim for judicial review succeeds, there will be protection for same-sex couples in the Cayman Islands. Now, finally, I want to say something about the common law very briefly. My learned friend has seemed to suggest at various points in his submissions that it could be said that in some way the common law had developed so as to encompass a right to same-sex marriage. We submit that is incorrect. In fact, the courts in both South Africa and Canada made findings that the common law did not include same-sex marriage, and that for that reason was unconstitutional and therefore had to be developed in order to comply with their constitutions. And you can see this in Halpern. It's page 1105, paragraph 37, and then page 1137, paragraphs 147 to 8. And the same point in Furi, page 1224, where you can see the declaration made at paragraph 120, 1297. So it's clear that the common law does not and did not give a right to same-sex marriage. In any event, in the Cayman Islands, the field was occupied in 2008 by the marriage law, which clearly didn't give a right to same-sex marriage. So there was never any right to same-sex marriage that was taken away by any provision in the Cayman Islands Constitution. Can I then turn to the second issue in this appeal, which is the question of relief, if my learned friend is correct on the first issue? Now, we have dealt with this in our written case. If I can invite you to turn it up, it's page 802. I don't intend to make detailed submissions on this unless the board would like to hear them, but simply to explain essentially what the issue is. The issue is whether the right remedy should be the modification of Section 2 of the marriage law to include same-sex marriage, or whether the right remedy is a declaration of incompatibility under Section 123 of the Bill of Rights, which then leaves it to Parliament to decide how to legislate. And in our submission, the latter is the right course. Now, the starting point is Section 5 of the Constitution Order, which you can see set out at paragraph 129 of our case on 802. subject to this section, the existing laws shall have effect on and after the appointed day as if they'd been made in pursuance of the Constitution, and shall be read and construed with such modifications, adaptations, qualifications, and exceptions as may be necessary to bring them into conformity with the Constitution. Now, we say there are two things that you get from that section. First, that existing laws made before this Constitution came into effect are to be treated as if they were made pursuant to the Constitution. And secondly, that they're to be modified insofar as it's necessary to make them comply with the Constitution. Now, we say that there is no necessity for any modification in this case. And the reason for that is set out at section 23 of the Bill of Rights, which you see set out at paragraph 134, page 803. This is the provision providing for a declaration of incompatibility. And section 23(2) says, a declaration of incompatibility shall not constitute repugnancy to this order, and shall not affect the continuation in force and operation of the legislation or sections in question. So we say that when you read section 5 and ask what modifications is it necessary to make to the marriage law to bring it into conformity with the Constitution, the answer is none. Because if a declaration of incompatibility is made, it does not mean that section 2 is repugnant to the Constitution. Now, the remaining wrinkle is the definition of primary legislation. Because if we go now to page 804, we can see at the bottom of the page that the provision we've just been looking at only applies to primary legislation, which is defined in section 28 to mean a law enacted by the legislature, and the legislature means the legislature established under the Constitution. So what the appellants argue is an existing law wasn't made by the legislature established under this Constitution, it was made by the old legislature. Therefore, it's not primary legislation for this purpose. Therefore, no declaration of incompatibility, and you have to modify under section 5. And our answer to that is the first part of section 5. The existing laws shall have effect as if they'd been made in pursuance of the Constitution. We say that the existing primary legislation is to be treated, is to be deemed to have been made by the legislature established under the Constitution. So that is the point which essentially depends on those questions of construction. We submit that there's still a function to section 5 because it applies to provisions of this Constitution that aren't within the Bill of Rights. The declaration of incompatibility process only applies to the Bill of Rights. And we say that makes sense because it recognizes that there will often be legislative choices to be made as to how to bring the Cayman Islands into conformity, where there's been found to be something unconstitutional in one of its laws in relation to individual rights. And the decision is to leave that to the legislature, not to the courts to decide. And we say there's no good policy reason to treat legislation enacted before the Constitution differently from legislation acted after the Constitution in relation to that principle. The final issue was costs, which I understand the board would like us to leave over until after judgment. And on that basis, unless I can be of any further submission, assistance.
Before you complete your submissions,
yes.
I think you might like to be aware that while you've been addressing us, we've received 3 additional authorities which Mr. Fitzgerald may rely on, or may seek to rely on in his reply. I don't know if you're aware of this.
I was made aware of it shortly before the hearing began today, my lord. I have had no opportunity to look at these authorities.
No.
and I don't know what proposition Mr. Fitzgerald is seeking to advance on them. So
Yes.
I reserve my position on that.
Yes. Well, shall we adjourn for the moment, and we can see at 2 o'clock whether you have anything you wish to add and how you would wish us to deal with this application to introduce fresh authorities in the reply. So we'll adjourn now until 2.
I think Mr. Fitzgerald wants to say something, my lord.
Yes, Mr. Fitzgerald.
My lord, in order to clarify, I did explain to my learned friend that they go to the question of the preamble, and they were referred to in the skeleton to the Court of Appeal, which I referred to yesterday, but unfortunately they didn't find their way into the bundle of authorities before the board. So they go to the question of the preamble, which was raised by members of the board yesterday. They were referred to in the Court of Appeal in the skeleton there. I did refer you yesterday to that skeleton, and I did tell my learned friend this morning that that's what they went to.
My lord, what
The
I don't know
reference
is
is
what,
to God.
yes, what I don't know is what the proposition is that my learned friend is seeking to derive from these authorities, because I will confess that I do not have a perfect recall of all points made in his skeleton argument to the Court of Appeal in 2019. So I'm not much the wiser.
Yeah. Well, it's about the reference to God in the preamble.
Oh, I
Well,
see.
my lord,
And do you want to take us to Lord Manson Larimore?
That's it. I did refer to it yesterday. It was set out that he said that the reference to God in the preamble can't cut down right.
Yes, yes.
well,
Well, we can return to this if need be after the
yes.
short assignment and find out what your position is as the best way of dealing with this. So we'll
Yes, my
adjourn now and resume at 2:05.